Hi, I'm Dr. Lee.
Hi,
it's nice to meet you guys.
Hi, I'm Mrs. Griswold. Hi.
Hi.
So, what brings you in today?
Well, first we are Mr. and Mrs. Chesley, and we've just gotten married. And we're not ready to have kids yet, so we were just wondering what our options are to stay safe and not have kids.
Well, there are many options available to you at this clinic. Do you have any benefits for her?
Yes, this is the most popular pamphlet that we give to all of our patients.
You can read over that at home, but are there any questions that you have about that right now?
Are there any other methods that you can offer us besides the condom?
Right, we have many other birth control options available at this clinic, but not all of them are legal. The state of Connecticut doesn't actually condone contraceptive methods, but this clinic does. That's just something to be aware of.
So you're going to offer us the service even though it's illegal?
Correct.
Okay, well, I guess we're willing to try anything, right, honey?
Yes.
Okay, well, thank you very much for having us.
It was nice meeting you.
Nice to see you.
Thank you. Thank you.
So, Dr. Lee, do you think we made the right decision in opening this clinic?
I do. I don't personally agree with the Comstock Act. I think that the state created this act in order to prevent illicit sexual relationships, and here we're counseling married couples, so I don't believe what we're doing is wrong.
You make a good point. I mean, the whole purpose of opening this center was to challenge this law and draw attention to how ridiculous it is.
You're right. I hope some new piece of legislation comes about because of this. Come in.
Are you Dr. Lee and Mrs. Griswold?
We are.
Mrs. Griswold, you're under arrest for violating the Comstock Act of 1879 for providing birth control to married couples under the state of Connecticut. Let's go. You too. Next up on the docket is case 529, Griswold versus Connecticut. Each side has 30 minutes to present their case. The defendant may proceed.
Hi, today I'm here to present Dr. Griswold in the court case that we are attending. So I first would like to read to you the Comstock Act. In it, it says, any drug, medicinal article, or instrument for the purpose of preventing contraception and subjected to the prosecutor to be fined not less than $50 or imprisoned not less than 60 days, no more than 1 year, or both be fined and imprisoned. The whole gist of this act is in order to prevent illegal relationships. So if we have a legal relationship here with the people that they were consulting and giving the contraception to, why are they unable to have it? If a responsible married couple wants to prevent themselves from having children, believing that they are not ready to have children yet, what's so wrong in that? Foreign countries have high birth rates and have high death rates as well because of their improper care for these children. In Prince versus Massachusetts, it also states a realm of family life which the state cannot enter. So in Massachusetts, they have a law which states that they cannot enter certain realms of family life, which is what should be implemented here in Connecticut because it is unfair to people that their family life is being entered in the court in the law system. In other cases, such as Knapp versus Ohio and NAACP versus Alabama, they also state certain principles that are similar to this case. Married couples that are not engaging in inappropriate sexual relations. They are engaging in what might be the most proper form of sexual relation, to be honest with you. So, thus forth, Connecticut should not be entering in the family life of these people who want to prevent themselves from having children that they believe they are not ready for.
The plaintiff now has 30 minutes to present his case.
I'm here presenting on behalf of the state of Connecticut. So, the 10th Amendment in the Bill of Rights gives rights to the states, otherwise not guaranteed to the federal government. So that includes acts like this Comstock Act. It is within our realm, it doesn't even matter what the law is, but as the state of Connecticut, it is within our realm of jurisdiction to be able to make laws like this Comstock Act. Nowhere in the 4th, 5th, or 9th Amendment does it grant a zone of privacy to the citizens of the United States. So isn't it our job as states to grant them that if we feel it's needed? Whereas Connecticut, we don't feel it's needed. We implemented this law for a reason, and it is still in place today because it is still servicing that reason. Therefore, the Comstock Act should not be repealed.
The court is now adjourned. We will reconvene when the justices have made a decision.
We were met with a wide range of questions that implicate the Due Process Clause of the 14th Amendment. We do not sit as a super legislature that can determine the wisdom and need of certain laws. However, when laws operate directly on the intimate relation of husband and wife and the physician's role in one of that, they need to be questioned. In NAACP versus Alabama, we protect the freedom to associate privacy in one's associations. We recently referred in Knapp versus Ohio to the Fourth Amendment as creating a right to privacy. The present case, then, concerned a relationship within the zone of personal autonomy. Forbidding the use of contraceptives rather than regulating their manufacture or sale is destructive upon the relationship. Such a law cannot stand in the light of the familiar principle, and it invades the area of protected freedoms. In NAACP versus Alabama, would we allow the police to search the bedroom of a married couple and look for contraceptives? The idea is repulsive to the notions of privacy surrounding the marriage relationship. We deal with the right of privacy older than the Bill of Rights, older than our political parties, and older than our school system. Marriage is a coming together for the better or worse, hopefully enduring and intimate to the degree of being sacred.
The Ninth Amendment was put into the Constitution by the authors in order to protect the fundamental rights of the people. In this court, we've interpreted the Ninth Amendment freely. We believe that this case has given us the ability to interpret the personal privacy zone of people. I do not see how this broadens the authority of the court. Rather, it serves to support what this court has been doing in protecting fundamental rights.
I agree with the majority of the court's opinion, but I don't believe that this law violates the 14th Amendment, although it does violate another amendment in the Bill of Rights.
Suffice to say that this is not the first time that the court has had the occasion to articulate the liberty entitled to protection under the 14th Amendment includes the right to marry and bring up children in Meyer versus Nebraska, the liberty to direct the upbringing and education of children in Pierce versus the Society of Sisters, and that these are among the basic civil rights for a man in Skinner versus Oklahoma. These decisions affirm that there is a realm of family life which the state cannot enter. I wholly fail to see how the ban on the use of contraceptives by married couple in any way reinforces the state's ban on illicit sexual relationships. Connecticut does not bar the importation or possession of contraceptive devices. They are not considered contraband material in the state of Connecticut, and in the state it is not seriously disputed.
I do not to any extent whatever base my view that this Connecticut law is constitutional in belief that the law is wise or the policy is a good one. However, if Dr. Griswold was expressing her opinions and teaching her clients how to use these different contraception methods, then the First and the 14th Amendment would protect her. But speech is one thing, conduct and physical activities are quite another. The fact is well illustrated by the use of the term right of privacy as a comprehensive substitute for the Fourth Amendment guarantee against unreasonable searches and seizures. The Constitution makers knew the change and provided for one. However, they did not provide for a specific zone of privacy. Because they didn't, I do not feel it is constitutional that we should grant the citizens of the United States one.
After careful consideration, though the Constitution does not explicitly protect the general right to privacy, the various guarantees within the Bill of Rights create zones that establish a right to privacy. Together, the First, Third, Fourth, and Ninth Amendments create a new constitutional right, the right to privacy in marital relations. The Connecticut law conflicts with the exercise of this right and is therefore null and void. The decision in the case is 7-2 in favor of Griswold, and the decision of the lower court is reversed. The case is adjourned. Are you Dr. Lee and Dr. Griswold?
She's not a doctor.
It doesn't matter! Okay. I'm sorry, I found low glow. I got excited.
Thank you.
Yes. I don't even know all these arguments.
Should you have a child?
Are you good?
The Ninth Amendment was incorporated in the Constitution. Stop laughing at me!
Go.
You guys do understand you just ruined my video.
Oh, I'm sorry.
It's not okay.
She wouldn't let go of my hand.
Different if Dr. Sorry, God. I just want to get this over with. Austin, can you please leave?
No.
You're distracted. Don't tell me to chill.
I